Happy middle of the week. My name is Michael Leeserman, here with the Trial Guide's Tip of the Day. The date is Wednesday, February 11th, 2026. Our tip today comes from the book Winning Settlements, from a chapter by Patrick Malone called Getting Better Settlements by Fighting Secrecy. Never ever agree to vague confidentiality when finalizing the oral settlement. Say exactly what you will agree to. Put it in writing in a settlement memorandum. Keep your goal in mind. The defendant's name and facts of the case must stay in the public domain. The details of the settlement are fine to keep quiet because that's in your client's interest too. So I think there's really two parts of this, and confidentiality agreements and talking about them can cause real disagreement between plaintiffs' lawyers and real strong feelings. So the ultimate guide is your client, right? You have to do what your client says and what's in your client's best interest. I guess first what they say, which is hopefully in their best interest, and that you would advise them as to that. Whether in any particular case that means keeping a dollar amount confidential or names confidential, there is certainly great public policy to argue that names should not be confidential of the defendants to help discourage continuing bad conduct that will injure others in the future, absolutely. And I think the great part of this tip is wherever you're coming from, whatever your client might want in a case, and the client might not be willing to go to trial if you call the defendant's bluff. And 99% of the time, if you do, they'll give in and not insist on the confidentiality. But there are some defendants that will not settle without the confidentiality. And at that point, your client might tell you you will settle it, right? You've got to consult with your client on that. So the great part of this tip is to not leave a vague oral confidentiality agreement. If you're at mediation, then go through examples, put it in writing. Is it the name? Is it the amount? Can the lawyer use this result in marketing? On and on. We've all been there where we thought we had a meeting of the minds and then we're in front of the court or threatening to be in front of the court on the details when it comes to the release. So you can minimize any friction and disagreements in the release language by ironing that out in the mediation statement, have something in writing. And I know some people will do this ahead of time, send terms of agreement ahead of time and start negotiating them. I've tried that. I usually end up doing it at mediation. I'll communicate what I want ahead of time, but I won't make it a precondition. Although many times I won't go to mediation anyhow, unless the court requires it, unless certain conditions are met. I talk about that in another chapter in this book that I wrote, Preconditions to Mediation. But anyhow, Patrick Malone's tip today is very helpful to not just agree to some vague confidentiality, at least spell out in writing what that means to everybody, or if that's not going to occur, no confidentiality, make sure that that's in writing as well. Let's take a deep breath together and be grateful to be alive. Now, as much as ever, it's important that we turn to the law in our society as a unifying and guiding force. May our actions as lawyers today exemplify the profession and its highest ideals of honor and truth. May we be fierce advocates and compassionate human beings. May we have the courage to do what's right, even when it's difficult. 3 sounds of the bell now will ground you in this moment and can take you into a silent meditation practice, a prayer practice, or just let the sound wash over you and remind you of your strength and your purpose to accomplish justice and to do good in the world.